Sixth concept is transnationalism. Professor Harold Koh, now State Department legal counsel, is perhaps the leading proponent of what he describes as transnationalism. He compares this with what he describes as the nationalist philosophy that has somehow taken hold of the American law for the past 220 years. He says, transnationalists tend to believe in the political and economic interdependence of nations, while nationalists focus instead on preserving United States autonomy. The transnationalists recognize that international and domestic law are merging into a hybrid body of transnational law, while nationalists preserve a rigid division between domestic and foreign law. Transnationalists believe that domestic courts have a role to play in incorporating international law into domestic law, while nationalists complain that only the political branches are authorized to domesticate international legal norms. Professor Koh, remember the counsel, the legal counsel at the State Department, now predicts that the clash between competing visions of constitutional law, as he describes them, between transnationalism and nationalism, will play out in future Supreme Court confirmation hearings, and that these will be pivotal in determining by the year 2020 the direction in which the United States law proceeds. He says, what the United States and the world will look like if we just let constitutional change happen, and what it will look like if we seize this moment to push our constitutionalism and our policies in better directions will be at stake in the next few Supreme Court confirmations. In practice, transnationalism would legitimize reliance by American judges upon foreign law in giving meaning to the United States Constitution. It would bind federal and state governments to international treaties and agreements that had never been ratified by the United States, much less enacted into law by Congress. It would render both the domestic and international conduct of the U.S. increasingly beholden to the review and judgment of international tribunals in Geneva and The Hague. It would expose American soldiers and elected leaders to the sanctions of international law for imagined war crimes and violations of the earth, and it would once again replace the judgments of officials representing the American people and holding paramount the interest of the United States of America with the judgments of European bureaucrats and multinational panels of judges, finally and precisely balancing the interests of this country with the interests of authoritarians and dictators throughout the world.